Mr. Douglas. Mr. Richards.
May it please the court. I'm Barry Richard on behalf of George W. Bush and Richard Cheney.
Mr. Richard, let me start with my question that I asked Mr. Boyce. When this case was here before, counsel for Mr. Bush did not present any argument on McPherson versus Blacker, yet when it got to the Supreme Court, counsel for Mr. Bush forcefully argued McPherson versus Becker. Now I know, Blacker, now I know that it's not argued again here. Is it the position of Mr. Bush that that case does not have any bearing on this matter?
Oh, Your Honor, I think that the case has substantial bearing on the matter. I think that what McPherson v. Blacker tells us is exactly as Your Honor suggested it, which is that this court does not have the ability in this particular case involving presidential electors to disregard the statutory scheme and fashion a remedy based upon extraordinary equitable powers of the court set forth in the Constitution.
Do we have the right to review the action of the circuit court?
Indeed you do, Your Honor, but we come here in a significantly different posture than we did before. What we come here with now is belied by the nature of the litigants and the public interest. In fact, this is nothing more than a garden variety appeal from a final judgment by a lower court that reviewed after an entire full evidentiary hearing.
But the legislature, having plenary power, said that the circuit court will make that determination.
Well, I agree with you, Your Honor, and I would not suggest to this court that the circuit court is not subject to any appeal. I believe that the circuit court is subject to appeal, but in a very limited fashion. And I also think that one reason that we have not placed emphasis upon McPherson versus Blacker is because, in fact, this court said the same thing in an earlier McPherson case, which Justice Wells referred to, McPherson versus Flynn, in which this court said, since there is no common law right to contest elections, any statutory grant must necessarily be construed to grant only such rights as are explicitly set out by the legislature. The legislature in Section 168 has given us 5 and only 5 grounds for an election contest, and one of them is not that there is a close election in which vote-o-matic machines are used.
Well, the bottom line, if I understand it, though, of your answer to the Chief Justice's question is that this court does have appellate jurisdiction over the trial court's ruling. It does not affect that appellate jurisdiction.
No, sir. I certainly believe that this court has the ability to review what a circuit court did to determine whether the circuit court violated the traditional rules.
Much in the way we would be reviewing it if it was another county commissioner or an election for some other office, a member of Congress, and a contest was brought.
Precisely, Your Honor. The court is the great leveler in the sense that it doesn't make any difference whether we're talking about school teachers and laborers or presidents and kings. The rules are the same. And the rules in this case are very clear. There are 2 questions that this court must answer. Was there substantial competent evidence in the record below to support the judge's findings? And did the judge properly apply long-established law?
Referring to the substantial competent evidence issue, isn't it highly unusual for a trial court to admit into evidence certain documents that one party claims will be controlling with reference to the claim they bring to the court, and yet never examine those documents before making their decision? And didn't that happen here with the trial court admitting the disputed ballots into evidence, but yet never looking at those documents?
Well, I think that the trial court theoretically admitted the ballots.
Well, theoretically, or the trial court either did or did not admit the ballots into evidence. Did the trial court admit those into evidence?
My recollection is that the trial court did. There were thousands of ballots which were embargoed, and my recollection is that the trial court did. It was not a substantial dispute over whether or not the court could technically admit them into evidence.
Did the trial court examine those documents?
No, Your Honor, because I think there was no basis in law for the trial court to do that until after the plaintiff had carried its burden of proving that there was some necessity to do so, and this leads to the core of
Then what does subsection 8 mean? the subsection that was specifically added in 1999, and you've told us we've got to follow the statute, that the section that says that the circuit court is to do whatever is necessary to ensure, which is rather unusual language to use in statute, to ensure that each allegation in the complaint is investigated, examined, or checked. If it isn't to mean that the circuit court is to look at the very ballots that have been brought to the court for investigation, what does that section mean in the context of this litigation?
Your Honor, this brings us back to McPherson versus Blacker. Neither the circuit court has no greater power than this court to disregard the scheme that the legislature has provided us with, and that scheme is crystal clear. In fact, this court recognized it 10 days ago in the Harris case when it said the decision whether to conduct a manual recount is vested in the sound discretion of the board, and cited Hogan. The Hogan case, precisely the same as this case, it was a case in which the canvassing board elected not to. This court referenced that case in which they said that the application of Section 168 does not change the necessity to show an abuse of discretion when it arrives at the court.
May it please the court, I think I remember the first question. We did not argue Blacker in the Supreme Court on behalf of the Secretary and the Canvassing Commission. But I think the answer to your question is this, that the judiciary obviously has the appellate power to review what a circuit court does. There is a constriction, however, and I think that constriction is picked up in the language of the Supreme Court, and that has to do with the concern in this kind of election having to do with presidential electors, which is different than the other kinds of elections, for instance, referred to as by Justice Anstead. And that is the language on page 6 of the slip that says, since Section 5 contains a principle of federal law that would assure finality of the state's determination if made pursuant to a state law in effect before the election, a legislative wish to take advantage of the safe harbor would counsel against any construction of the election code that Congress might deem to be a change in the law. So I suggest that is the restriction that you would have. The legislature has the power to select electors. In Florida, the legislature has allowed the people to make that choice. But I think, Mr. Chief Justice, that what you need to do is you need to be careful in terms of construing statutes or remedies to not do anything that would constitute a change in the law, because if that is done, then that places in jeopardy either the safe harbor, if the Supreme Court limits itself to that, or the concept that any kind of change of law...
Why hasn't that been accomplished in our previous decisions that gave due regard to the fact that you have a federal scheme that has certain fixed dates or a calendar in place, and that we have interpreted the statute to be certain that the votes are counted and finally counted before that fixed date comes into play?
Well, I think about the part of that U.S. Supreme Court opinion of Monday that Mr. Clark just referred to, and that is that the U.S. Supreme Court did say that a legislative wish to take advantage of the safe harbor would counsel against any construction of election code that Congress might be deemed to be a change in the law. However, doesn't that also mean that if we're going to have it take advantage of Section 5, that all of these contests have to be concluded, as you told me before, when we were here before, by December the 12th. And we don't have a remedy here that can do that by December the 12th.
Your Honor, I think you do have a remedy that can do that by December 12th. I think first, almost all of the issues, in terms of number of issues, although not in terms of number of the ballots, are now legal issues before the court. The 215 ballots in net votes for Vice President Gore that have already been identified as legal votes by the Palm Beach Canvassing Board and are not disputed by the defendants.
Just on that, there was in Governor Bush's brief a reference to an audited return that showed 174, and since numbers seem to be pretty critical here when there's such a small difference, do you agree that with that later number from Palm Beach County?
We don't agree to it, but even their offer of proof, which was submitted after the trial was over, and which is where that number comes from, I think only related to the numbers submitted as of 5 p.m. The 215 number is a number that goes through 90 minutes afterwards when they completed their count.
And that information's in this record?
That's in the record. It's in the Palm Beach answer to paragraph 60 of the complaint, and it was in Mr. Judge Burton's...
seriousness with which everyone has addressed this matter. Court will be in recess.